charges.
Can you explain that part for a second, Robert? Because people beat me up on this all the time. They beat me up, and they say, no. Former president, current, that's no different than anybody else. But isn't it, to somebody who's done the job and to other prosecutors, do you weigh all cases the same, or does that, is it in the public interest part, mean something in the analysis?
Well, it does mean something, because even if, the principles of federal prosecution, which the Department of Justice applies to anybody, including presidents or former presidents, even after you've made a determination that you can prove to a fair-minded jury beyond a reasonable doubt the guilt of the defendant, you still have to weigh the consideration, which is equally relevant, about whether it's in the federal interest. You comment about it in terms of talking about the public interest, basically the same idea, but whether or not it's in the federal interest to bring such a prosecution. And, that's a much more difficult question. And we're in you're right about the fact we're in uncharted waters here. You're having to evaluate this case now based upon a referral and the department's pre-existing investigation through the special counsel with against an announced presidential candidate by an adversary who's the current president of the United States, who's likely to run for re-election, whose Justice Department, led by Merrick Garland, is the one responsible for deciding whether or not to bring a prosecution. I think that's fraught with all kinds of peril. You can talk about the fact that no one's above the law, and I'm not here to argue to the contrary. I spent a good part of my professional career trying to vindicate and uphold that principle. But, you also have to factor in, when to bring, if a prosecution were appropriate, would it be in the federal interest to bring one now during an election cycle? Or whether it would be better and in the public interest ultimately to defer and allow such a prosecution if it is to go forward once the election is over.
Yeah, and then that brings in is that why he said he wants to run, is to forestall any prosecution efforts against him. That would be an unusually strategic tact for the man that you and I both know, but it does raise that question now. One other point, and then I'll let you go. The idea of they made a solid showing of proof that the former president knew from multiple sources that what he was trying to sell to the American people was not true and was dangerous and was a false premise to try to stop the certification of the race. Is that criminal?
It depends, Chris. Selling it to the American people, if that's the standard against a politician, then I guess everybody would get locked up.
You know it's not true. You sign it in legal documents. You try to organize stopping the certification on a premise is untrue from multiple sources.
And he'd have to, and the prosecutor would have to show that the former president knowingly did that and participated in that conspiracy, and that those statements were going to be made to someone either in federal law enforcement or a federal official. And that
we signed the legal papers,
was engaged in that, knowing that it was a violation of the law. I think I can imagine a circumstance, Chris, and this may be somewhat anomalous, where, as based upon the committee's referral, that the Department of Justice may well think that a prosecution against a lawyer who presumably should know better, like John Eastman, might well proceed. And I could imagine circumstances where I could see that happening. I think it's another thing altogether, though, to say that, Donald Trump was at all events trying to do at all costs to win this election. Well, of course, every presidential candidate is about doing that. Now, presumably their conduct, doesn't stray beyond the boundaries of the law, but that gets to be a very difficult question, it seems to me, to prove. And their top charge, which is the one they led with, the committee, was obstruction of an official proceeding, and that requires, as you know, proof of corrupt intent, which is a higher burden that the prosecution has to satisfy in order to successfully prevail before a jury. I find that very difficult under these circumstances to imagine that the government would be able to prove that. So, I think there are proof problems even before you get to the question of, whether or not it's in the federal interest to bring such a prosecution. And I think ultimately what should happen here.
Go ahead.
Go ahead. Well, I was going to say, what I think should ultimately happen here is that there should be a little more faith in the ultimate justice of the people, to paraphrase Abraham Lincoln. I think, the ultimate justice of the people are for the people to decide that they don't want him back in office. I think
Yeah.
that's the way to go about this. I mean, the principal motivating factor by Liz Cheney and everybody else seems to be to bring charges against the former president to prevent him from being a candidate for office. I don't think that it's the prerogative of the committee or for a single prosecutor or for Merrick Garland or, frankly, obviously, for Joe Biden to be deciding on behalf of the American people who should be president of the United States.
Hey, thank you for watching. Please go to newsnationnow.com, newsnationnow.com, and you can find NewsNation on your television provider. And don't forget to click the red subscribe button down below. Then you will get more of NewsNation's fact-driven coverage.